a deep breath with me. If you are living in the United States today, or hoping to one day join your family here, you already understand how heavy immigration worries can feel. Many people carry questions silently. Am I safe here? Is my status protected? Could one mistake change everything? If you've ever had those fears in the back of your mind, you are not alone. And I want you to know something important. Understanding the rules gives you power. When you know what can put your status at risk, you can protect yourself, your future, and the people who rely on you. Today, we're going to talk about 5 situations that can place green card holders and legal workers in danger of deportation, even those who have lived in the U.S. for years, follow the rules, and contribute to their communities. This information isn't meant to scare you, it's meant to guide you, so you can move through life with confidence rather than fear. The first area we need to talk about is criminal convictions, especially what immigration law calls aggravated felonies. Many people hear that phrase and assume it only applies to serious or violent crimes. But immigration law defines aggravated felonies much more broadly than most state courts. Something that seems small on your state record can be treated as major under federal immigration rules. Theft, certain types of fraud, assault-related behavior, and crimes involving physical harm, even if they result in little or no jail time, can still be labeled as aggravated felonies for immigration purposes. Imagine someone accepts a plea deal, thinking it's the easiest way to close a case. Maybe the attorney says, "You won't serve jail time," or "It's only a misdemeanor." But immigration authorities don't look at cases the way local courts do. A conviction that seems minor at the state level can automatically trigger removal proceedings at the federal level. And once that happens, fighting the case becomes extremely complicated. This is why anyone who has ever been arrested or charged with a crime needs to speak with both a criminal defense attorney and an immigration attorney before agreeing to anything. A simple yes in court can have consequences that follow you for the rest of your life, even if you've lived in the U.S. for decades. The second major issue involves drug charges. Many people in the U.S. believe that possessing a very small amount of a controlled substance isn't a big deal, especially in states where certain drugs have been decriminalized. But immigration law operates under federal rules, not state rules. Even tiny amounts of illegal drugs, cocaine, heroin, unprescribed pills, or other controlled substances can make a resident deportable. There is one narrow exception for first-time marijuana possession under 30 grams. But outside of that, the law is extremely strict. Even if a local judge dismisses your case, or you complete a diversion or education program, immigration officers may still treat the situation as a violation if you admitted guilt along the way. Think of it like this. Criminal court may forgive, but immigration court may not. That's why immediate immigration guidance is essential when dealing with any drug-related case, no matter how minor it seems. The third area we must talk about is family and domestic disputes. These cases are taken very seriously in immigration law, even when no one is physically hurt. Many people don't realize how broad the definition of domestic can be. It can include your spouse, your ex-spouse, someone you live with, your partner, your children, stepchildren, and even extended family members who share your household. Domestic incidents don't always look like what people imagine. They can involve raised voices, a heated argument that leads to a 911 call, a misunderstanding that results in a protective order, or even a violation of an order you didn't fully understand. Something that appears small in state court, a misdemeanor or a nonviolent charge, can still put a green card at risk. And once again, plea deals can be dangerous. A person might accept a quick plea just to get it over with, not realizing that the immigration consequences can be far more severe than the criminal ones. Before accepting any agreement in domestic-related cases, get immigration advice from someone who understands how the system works. Now, the fourth area, immigration-related fraud. Many people hear the word fraud and imagine something big, fake documents, a made-up identity, or a sham marriage. And yes, those are serious. But sometimes fraud is much simpler. It can be a mistake you didn't think would matter, a small detail you didn't correct on a form, a situation where you accepted help from someone who filled out your paperwork incorrectly. Even a misunderstanding can raise red flags years later. What many people don't know is that immigration authorities can reopen cases decades after approving a green card. If they find that information was incorrect, inconsistent, or misleading, even unintentionally, they can start removal proceedings. Fraud doesn't expire under immigration law. If the government believes your status was obtained through misrepresentation, they can challenge it at any time. That's why it's so important to review your past applications, tell the truth on every form, and avoid advice from unlicensed consultants who make promises they can't keep. When it comes to immigration paperwork, honesty and accuracy are your strongest protection. The fifth situation may seem small, but it catches many people by surprise, failing to update your address. Every green card holder and visa holder must report a change of address within 10 days. It sounds simple, but it's legally required. Many people move homes, change apartments, stay with family for months, or relocate for work, and forget to update their records. Why does this matter so much? Because immigration notices, court dates, and official letters are sent to the address they have on file. If a notice goes to an old address, immigration agencies will assume you received it, even if you never saw it. Missing a notice can have serious consequences, including a removal order issued without you ever appearing in court. Updating your address takes only a few minutes online, but failing to do it can create a chain reaction of problems, especially if other issues arise at the same time. The truth is that immigration enforcement in 2025 moves faster than it did years ago. Cases that once took months now move in weeks. Judges and officers are issuing removal orders at a quicker pace, and even small issues can escalate before a person has time to understand what's happening. That's why staying informed and proactive is no longer optional. If you face any type of legal trouble, criminal, domestic, or administrative, talk to an immigration attorney before making decisions. A deal that looks easy and harmless in criminal court can be devastating under immigration law. Never rely on assumptions. Always rely on professional guidance. And beyond legal issues, protect yourself by keeping your documents organized, your records honest, and your personal information up to date. Track your taxes, maintain proof of your residence, employment, and community ties, and take your immigration responsibilities seriously. These simple habits build a strong foundation that helps you if you ever need to defend your status. Your green card is not just a document. It is your connection to your family, your job, your home, and your future in the United States. It deserves your care and attention. When you understand the rules, you give yourself the best chance of staying safe, stable, and protected. If you want clear, calm explanations about U.S. immigration law, I invite you to subscribe to Legal Focus USA for more helpful updates and guidance.